Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 232nd video. And this video is in continuation to my happenings in the past. So this bungalow number 4 of Jalandhar cantonment, which has been resumed recently under an order of resumption, and the party had approached me and I had made a Janam Patri for the same. After the making of the Janam Patri and his consultation, the desire of the bungalow owner drifted towards another consultant. That doesn't affect me, but I really wanted what is the other consultant from Jhansi and the two brothers from Jalandhar cantonment who are the guardian of all this happening. This bungalow number 4, to begin, this is the plaint copy. Okay. So the whole copy with some paras of about 17-18 filed by Vikas Kumar Gupta and Ansh Gupta advocate. Through my sources, I managed to lay hands on the plaint. So this is Jitinder Chopra, aged 79 years, son of late Balraj Chopra, bungalow number 4. So the resumption notice given was to him. Why it was given? Because the present HOR who had purchased this property in 2002 till date hasn't got himself mutated. And to begin only, I will speak on that the biggest mistake what this plaint has been done on is that the similar thing what Mr. Deepak Agarwal, my working president, made a mistake way back, I think in 99. He filed his entire case on the behalf of their HOR, who was in the documents, Miss Chitra Kumari. Till Supreme Court, the case was filed by Chitra Kumari after losing from High Court. You know, sometimes advocates give us a brief that since the notice has been issued to Dr. Nath, recorded as HOR of bungalow number 4, GLR survey number 120, and area approximately 3.05 acres. So this notice has gone to them. And who's now coming on behalf of him is his grandson, that is Jitinder Chopra. Now, Jitinder Chopra ji is a doctor or not, I really don't know. But somewhere in my research, when I was making the Janam Patri, their family settlement did come to me, and how this property went to Jitinder ji is to be seen. You know, they had a family settlement through a court date or whatever, 1961, when Dr. Ramnath died in 1954. So this case is very important. You know, I've been telling most of the bungalow owners, and why this becomes a little personal to me, since I had made the Janam Patri. And in between the illegal HOR which he presumed Mr. Vipin migrated to the Jhansi consultant. Never mind, I would be the happiest person if the Jhansi consultant is in the position to plead what has been researched in the last 10-15 years. So the very first thing of this plaint is that it is Jitinder Chopra. So the Mr. Vipin Kumar is nowhere in this case. The notice has been issued to bungalow number 4 and it has not been issued to bungalow number 4A, because they both have separate survey numbers, and they in 1909 or somewhere or 18 had been, the grant had been bifurcated. Now let's go one by one. I have said that he made Union of India, Defence State Officer, SO Land and additional commandant headquarter station cell. So where this idea of making SO land the party, I really don't know, because SO land has got no designated post as per the Government of India's order. It is a reinstated post of a retired army officer in the station headquarter. Could be Ambala, could be Amritsar, could be anywhere, but it is a retired officer. So he could have filed this case against the Commander-in-Chief Western Command. He could have filed it against the station commander Jalandhar. Instead of bringing in Union of India, okay fine, want to bring in, he should have specifically brought Director General Lands, because Director General Lands is the signatory to the resumption notice. So well, these things are not debatable, but they can be always be more, we could be more precise on it. So well, whatever has been done has been done. The case has been filed and it has been fixed for, I think, 3rd September for final arguments or a written reply. So now the very second para of the pleading is, which is the main para, is a suit for declaration with respect to bungalow number 4, where resumption notice is spoken of and bungalow number, GLR and everything has been detailed. Why didn't he plead that this bungalow was a grant given in 1851 and it was a joint unit as 4 and 4A? When was the grant divided, under which order? The original grants should have been brought, because somewhere down the line he'll be pleading where he'll say get the original grant. So when he's by himself admission, he's coming on to an admission that yes, this bungalow from the original size of approximately 3.82 acres has been divided into 2 parts. The eastern sector is 0.77 acres, which is bungalow number, I think, 4A, and given a survey number 119, and this balance is 4, survey number 120 with 3.05, and this is being resumed. What is to be pleaded and what is not to be pleaded is very important. So now he is seeking permanent injunction for not interfering into the possession and a peaceful possession, and he's even mentioned the dimensions. Dimensions, I mean, is what is on your east, what is on your west. So here he is admitting that on east is bungalow number 4A. Now Jitinder, the plaintiff, is the owner of bungalow number 4A either, and he is the owner under the pedigree of Dr. Ramnath, owner of bungalow number 4. So why weapon was not brought in? Is it a sale without permission which has been restricted under the Governor General order? That has to be seen. So well, permanent injunction, fine, you ask for it, is nothing. The longer the possession, fine, under the registered title deed, and he could have pleaded in this. There was an illegal division of the old grant which was not allowed. But chalo, fine, whether done or not, we can only look into this. He's been mentioning the sale deeds. He's been mentioning the sale deeds from 1928, not the 1904 sale deed. So these all things, and neither is he mentioning that the family settlement had sold this property in 2002 to Mr. Vipin. Now, if Mr. Vipin was not willing to fight this case or was not willing to become a plaintiff, he could have always become a pro forma defendant. He could have been bought on records that the property has been sold to him. So some mistakes which were quite similar to bungalow number 65, and I don't know why this Jhansi consultant did not actually really look into all this. Well, that's it. So these are the opening paras. So mostly the judges are more concerned about the opening para and the prayer. So we'll talk of the prayer in the last. Now the plaintiff in his para 1 is pleading owner. He's lost his case. I guarantee he will lose in the constitutional court when he reaches the High Court and the Supreme Court. I am surprised and shocked How can this Jhansi boy do this? So many videos of mine have been continuously saying, please plead that we are old grants, never converted into new grants. So this pleading is disastrous. Now possession, he's asking for a status quo that my possession should not be disturbed. But has he pleaded? He could have very clearly mentioned that I have been sitting in this property since 1851. Because the GLR speaks of 1904 sale deed. When was the GLR made? What were the records in 1904 when the GLR was not in? So there were so many things regarding possession which could have been asked for. So bungalow number 4 in para 2 was owned by Rai Saab. Lala Fateh Chand agreed. Where did Lala Rai Saab get it? He got it from Karwarji Kusti ji. I'll be mentioning all this. So we have to understand, as grants in 1851, if the GLR is speaking, the biggest pleading what should have been done that prior to 1904 to 1851, from 1851 to 1864, admitted how this property came in the hands of then officer, and was he entitled for 3.282 acres of land as per his rank, because grants were supposed to be of fixed size under the PWD order of 1810. Again, this Jhansi, he's a bungalow owner, Jhansi consultant. He himself is facing a resumption case. Why didn't he bring this sale deed of 1904 when Kovarji, Astij Mehta and Idrun Parsi was selling this property? And I'll just show it how this property in 1919 was transferred from Narsingh to Lala Fateh Chand. These all documents were there. And I made a video of bungalow number 4. While Dr. Ramnath died in 1954. From 1954 to 83, why was mutation not done? So these are some questions which need to be asked. So well, these kept going, only oral partition between brothers. This is what the plaintiff is pleading. And that's how the plaintiff has become, Here specifically, the plaintiff should have pleaded that under the suit 34 of 1966, we family pedigree bifurcated this property likewise, and then that pedigree further bifurcated this property under a settlement of 1990. All documents were on table. So this is how this pedigree grows, and this is how bungalow number 4A went to the Mr. Jitinder, and 4A was on a joint platter which had to be sold. And that's how Mr. Vipin flew in after he did a sale in 2002 by an amount of 45 lakh rupees of 3 point. So why are these points missing? I don't understand. Now mutation, the DO has written a letter in 1983. The owner has written a letter in 1983 that the mutation may be done, and he has even tendered an admission deed, which originally Dr. Ramnath had not done. So these things should have been brought. Again, the plaintiff doesn't talk about this. Now the plaintiff in para 5 is claiming ownership and possession through the predecessors for the last 100 years. Acceptable. It could have been 150 years from 1851. See, ownership is very dangerous. And these consultants who have risen from not much of research, but from the books which have been shared from the All India Cantonment Bungalow Owners, which Jhansi Bungalow Owner was shared during those days in 2010, when we visited Jhansi. This is wrong. Because before 1836, how will this Dr. Ramnath or this consultant prove that Jitinder is the owner prior to 1836? Because 1836 the GGO was influxed. So you don't have a sale deed prior to 1836. So the rules and laws would only save you. The Britishers from 1765 started making rules. This is one big mistake. I don't know what is he trying to plead. We could have very easily stated here that yes, I am an old grant. Whether I am an old grant as per the GGOs of 1763 or 1795 is a matter of evidence. Who will bring that evidence? Either I will bring it or because since I have become the plaintiff, so the onus lies on me. So these many things could have been pleaded in para 5. Now possession for 100 years makes no difference if it is proven to be a government land. There are so many Supreme Court judgments now that adverse possession will not be given on government land. Para 6, he is pleading section 144 2006 Act. This is a section which says repairs of the bungalow. Guys, please understand, the bungalow owner is not coming with clean hands. He should have admitted that the department had let the bungalow decay and it is a mass of ruins now because of their mistake. But here I don't know what is the consultant trying. He's even trying to claim into these different obstructions by the defendants of not letting the HOR repair the bungalow. That is Dr. Ramnath. Then how is 4A being repaired? I'll just show you what are the mistakes. In 1918, there was a sanction plan of this bungalow done by the cantonment board. 1953, again this bungalow owner jointly, bungalow number 4 and 4A, got a notice under section 179 for unauthorized construction. Again a notice came and a board resolution number 3 of 1952. Similarly, the EO again in 1974 tried and issued a resumption, unauthorized construction notice. 1969, the property was joint till then. The new HOR, Vipin, has written letter in 2003 seeking permission for repair. So he's made no pleadings of this. And when you don't have pleadings, what are you going to fight? No pleading, no evidence. No pleading, no issue. I don't know. I'm not saying it is wrong or right. I pray the consultant of Jhansi is able to sail them out. Just garnering a stay and breathing yourself for next 7-8 years in the lower court is of no relief. Now para 6, he says mutation in the GLR was never done. Why was it not done? There is a policy to it. There are rules laid in CLA rules, how mutations have to be done, how sale proceeds have to be told. Nothing has been pleaded. All is he's writing that if we go for mutation, then the department would seek various kinds of affidavits, admission deeds, documents in writing that this land belongs to government. There is a procedure under which the government asks for that. It doesn't ask you in a Wimson Fancies order. There is an executive order. There is a rule which says that why admission is in. If we are covered under the GGO says that an acknowledgement has to be given. Where is it written? I am asking these two brothers of Jalandhar who are the custodians nowadays. So, you have to read a lot. But if you do not get this evidence, you are finished. So, no evidence in the plaint is mentioned that Dr. Ramnath actually refused to give admission. And there is a full report of a confidential report of the Army headquarters of 1930 when the GLR of bungalow number 4 was being upgraded. So, where is all those documents? Where is that resolution of 1919 and 1918 when this grant was divided by a board resolution? These things had to be brought onto the case, but they are missing. Now, where are these points? Where are these pleadings? How was this grant divided? Instead, it is written in all the Governor General's order and military and Commander-in-Chief orders that a grant cannot be divided without the permission of the Commander-in-Chief or the Government of India, then the British government. So, who in 1919 gave powers to the Cantonment Board? That has to be seen. Now, there are Supreme Court judgments that part resumption or partial resumption of a grant cannot be done. I presume this Jhansi consultant doesn't know these judgments. Had he known, he would have influxed them. This is where I get scared when you don't have full records, when you are not holistically covered under everything, you make mistakes. And nobody is fully educated. I am not. I am in my learning phase even today. That is why I read these plaints and orders which are filed. That is why I keep racking my head that if one loses, everybody loses. Now, para 8, what the plaint is saying, that the resumption was done in 1929. Where did this bungalow owner picked it up? He picked it up from my video, because it is in the history of Jalandhar, which was shared by a bungalow owner. And these two brothers recently photocopied those documents from me when I was in Jalandhar. Sometimes वो हिंदी की कहावत सच हो जाती कि बंदर को मिली अदरक की गांठ और वो समझा मैं पंसारी. This is the status of both these brothers and this consultant. So 1929, nothing is known about this resumption. Did it actually take place? In my video I have mentioned. Did it actually got redundant? So there are so many things. Now in para 9 he says 1991 again a resumption notice. Absolutely wrong pleading. It was a proposal in 1991. Now the GE then had valued this building. Now this owner or this consultant could have merged these two pleadings, that in 1991 bungalow number 4 was valued to 1,92,000. And the resumption notice of 24 says it is a mass of ruins and there is no value of the building. So his pleading for construction or section 144 of repair could have been clubbed. Sometimes we don't know how to club things, but we know how to speak things. You have to chronologically club your pleadings, because then you can bring in evidence on it. And that's the procedure, how an issue is made. Again he says, after 30 years a resumption notice is given. Where is it written in the resumption policy or in the Governor General order? Once a resumption notice given cannot be. He has not read the CLA rules, that means. If you read the last pages of 370 to 389 of CLA rules 1937, you understand. How many resumptions took place and those bungalows have been now converted into leases? So after a resumption, the property is leased. So these are immaterial things. Now he says in his para 11 that when we received this resumption notice, after this resumption notice, we filed an application, some dated July 2024, and we seeked some documents. Now, what are those documents? He's seeking application for grant. Where is it written? It is written in the Governor General Order 179. Sometimes we don't realize this is an indirect admission that if I am a grant, I am to be done like this. So his para should have been in a different format. English, you have to have a very good command on English. Then only can you write these lines. Now he could have said, proviso if I am a grant on a presumption under GGO, either of Bengal Presidency or Bombay Presidency or Madras Presidency, because Punjab was never a presidency of the British. It came under the northwest frontier. He doesn't know all this. When you don't know all this, you bound to make such mistakes. What can I do? Now he says, give me a certified copy of the grant. There are n number of judgments that vernacular record does not. I have a judgment of 1910 of a cantonment. He doesn't have it. Most of the people don't have it. Where in 1910 the court wrote that the vernacular record of the original grant does not need to be produced. What do? He's ruined this case, and Vipin, for I don't know, some meager financials, he moved out. Either he couldn't afford me. Sometimes bungalow owners sound to be very rich, but they actually, sorry to use this word, they can't afford me. So I'm surprised. Now he's asking, give me the receipt of the application of grant. I have a receipt of Belgaum of a grant. So that means that I am a grant. Well, I applied for a grant, but the grant didn't come through. So will that receipt prove that I am a grant? The grant has to flow in also. Nowhere is he saying that whether I was given a grant which was a barren ground or a built up house. Nowhere is he saying this. Because he doesn't understand what is the difference between a ground or a house. These demands under GGO is going to be very dangerous for this entire case. Now he says, give me the sanction plan. There is already a 1918 sanction plan lying over here when this bungalow was given a sanction. So the department does not need to produce the 1851 sanction plan. It must have changed. And by the permissions, Ghaswala said sanction, 1911. I'm sorry. Now he is asking for a property register of 1899. There was no property register of 1899. The code had regulations, and the property register was the house property register of 1833. Similarly, he is asking for registers under the CLA rules. Now he has mentioned these rules 12, 29, yes, they are all there. Now these registers said that the MEO or the cantonment magistrate will have to maintain all these documents. Now, these were under the CLA rules, not the cantonment code 1924. I don't know what is he writing. There is some communication of misinterpretations of the facts. Either the person who's typing this did not know, something is going wrong somewhere. So we need to understand all this. Regarding vernacular record, I already told you. Now central government title of proof, 2 places in the Cantonment Act 2006 as well as in the CLA rules that it is in, what is the record to be permanently kept. Had this consultant from Jhansi read the entire CLA rules, these people are basically educated on my Excel sheets. 2011-12, I used to post Excel sheets on mails. And those were only those paras which were important of the CLA rules, because it's a book of 400 pages. So I presumably used to think that nobody will read the whole book. So let's give people to read what is important. So he's not read it after that. Had he read that book, there is somewhere it is written in CLA rules that the title deeds have to be permanently maintained and sustained by the MEO or the cantonment board. Now why is it? It is because of the 1864 to 1924 order that the cantonment executive officer would be the sub-registrar of the cantonment. But where on earth to prove this? Now he says, bring the grant register. I got that grant register in Landor's case in Supreme Court in 2016-17. The bungalow owner lost. I keep telling people, asking for sale deeds, asking for land records or grant registers, you people don't know how to prove that grant registered wrong. Now if he has to bring that grant register, he has to read these 2 orders two financial reports, the Wells report and the Beckman's report. What do they say about these grants? And how grant registered? You people will be surprised. There were grants in Shimla, there were grants in Missouri. There were grants other than cantonments either. So the disposal of records, if this person had read in CLA rules, he would have categorically pleaded this. And he would have clubbed it with 1864 and 1924 powers of the cantonment magistrate. So evidence. Now the onus shifts under the Evidence Act. But who does all this? Small things matter a lot. Para 12 now coming to, he says, the resumption notice is null and void. Fine, agreed. He talks of some history, 1928, partition, and same paras he is repeating in this. No opportunity of hearing. So he is going on natural justice, which everybody does. So natural justice is that I was not heard before issuing a resumption notice. So let me be heard and then issue a resumption notice. Is he trying to say this? He should have pleaded why this resumption notice, as per the government policy itself, as per the GGO 179 itself, it had some procedures laid down and those have not been adhered. So my right to my right to compensation or my right to be heard has been jeopardized. I don't know. He doesn't even have the reports of 2003 when there was a survey done by the Under Secretary, Ministry of Defence for the Punjab and Ambala cantonment, Ambala, Firozpur, Jalandhar, Amritsar. He doesn't have that. What does that speak? No reason of resumption, he says. The department does not need to give you any reason. He says there has been harassment. Obviously, when you are given a resumption notice, you are harassed. Obviously, when under section 144, you are not given permission to repair because they presume you already been a convict into a lot of unauthorized constructions from 1928. Notices are being issued on a regular interval, 28, 59, 63, 74, 91. So, you are an offender. But what is being constructed? I don't know. Because today this bungalow is a mass of ruins. So we have to understand, when there is no building, we have to be very cautious about our pleadings. Okay. Now he could have very clearly said that if the DG, in one of his sub-paras is saying that it is the DG or the DO is incompetent of issue. So he could have written the authentication rules in 1954 and should have mentioned the delegation chapter in Cantonment Volume 2 book. Who has the power to issue resumption notice? He could have even pleaded the performer notice of the resumption notice. He's not pleaded, he's not compared the two notices. He could have pleaded the land audit procedure of the resumption. He's pleaded those paras 1, 2, 3, 4, 5, A, B, C, D. He's copy pasted all that. But what is the point doing all this? He could have asked for the KLP for Jalandhar cantonment. He could have sought the surplus land status of Jalandhar cantonment. But none of his letters of 2024, which he claims, he's asking those frivolous RTI. Basically, this consultant is an RTI activist. I think somebody in his family is an advocate. They've clubbed together. And an activist has become a consultant. You cannot just be on one track. I was a victim. 2005-8, I was the first one to file RTIs in this place. Then I even coordinated with the department and I researched their records. 5 judicial records and record rooms I sat by myself. I dug into registries, sale deeds, court orders from 1865. I was in the Archives Library. I was in the National Library, Calcutta. I was in the Shimla Library of the IAS Academy. So these libraries provided me all this. I sat down in the Lok Sabha Secretariat Library. I dug in records from 1865. I have the original plan of 1833 of India or British India. What was the territory with the Bengal presidency? What was with Bombay? What was with Madras? So you have to study a lot. You just can't come up and make pleadings and charge 40-50,000 and then start asking for 10,000 rupees per visit. एक कहावत बहुत सही है, सस्ता रोवे बार क्या बोलते हैं, महंगा रोवे एक बार, सस्ता रोवे बार बार. People will not improvise even today, I'm telling you. I know it. So, now he says in the 6th para of the same 12 that the GLR is fabricated. How is it fabricated? Where are those orders written that this is fabricated? By just digging into some order that the revenue record does not prove ownership, you can't prove the GLR wrong. Because 2001, Surinder Kumar Vakil, GLR has been upheld. So you have to read CLA rules in 1925, when first the GLR was made. And prior to the GLR, what was the land record system? So, now he speaks that the GLR speaks of B3 lands. He's referring to Rule 4, where it is classification of these ABC lands. He's reproducing the entire B3 land category. He reproduces that B3 ke andar there is B2, there is B category 3. He's puzzling himself. He doesn't know B2 land or B1 land or B4 land or category 3 land is separate to B. Category 3 does not mean B, A or C. Category 3 means that I am a private land and except 3 jurisdictions: sanitation, building safety and taxation. Nothing else can be imposed on me because I am a private property. So he is mixing himself in category 3 and B3, and then he is defining B3 complete as written in the CLA rules. He should have read the CLA rules in 2020 also, that the B3 definition has been amended. So, you have to understand what is to be done. Then only we can proceed further. So, basically, admitting to category 3 land or B3 land, the minute you say I am classified under A, B, C, Rule 1925 CLA says that all lands classified under A, B, C are under the majesty of Queen. So you are gone. You're finished. Somebody way back was discussing with me, Mr. Das, B3 means private lands. Please, yaar. Please, for God's sake. You have to club these laws. You can't read them in piecemeal. So now nothing is left, And now he says bungalow number 4 is a B3 land. Gone. Finished. The case here goes down. You said I am owner, I am B3. Finished. You rest in peace, Mr. Vipin. These 2 boys of Jalandhar have screwed you basically. Sometimes we become very fancier about our knowledge. And knowledge is not something to laugh at. Knowledge is something we need to save each other. So, what do? I really don't know. Now in plaintiff, he simply should have pleaded, I am category 3 land and my GLR speaks of the various things. So forget it. Now he pleads, if DG land was given power to him. Now look at what he is doing now. In the earlier para, he is saying the DG did not have the powers. Now here is saying, let's presume if the GG was given. This is discriminative pleading. The entire case will fall on these two pleadings of his. What is he doing here? I'm feeling bad. I don't know, this bungalow owner, Mr. Vipin, used to make me feel, Mr. Das, I'm in England, I have staff members, I don't know, people sometimes talk of their richness. But they are pettily, I think, poor. Because I understood, I shared with him, Mr. Vipin, you are not living in this bungalow since 2002. It has become a mass of ruins. On your retirement, you want to shift. Why not you go straight for compensation? Because you will not, another 7-8 years you fight with the department. Let's presume 1% you lose. As a consultant, I'm supposed to give him the right advice. Now what will happen here? Maybe, let's presume this stay is given. 4-5 years you fight in the lower court. You reach the session another 1 or 2 years. Then you reach high court. These 2 points will kill you in high court. That's it. Because the onus is entirely on you to prove that you are a freehold property. You are an owner of the property. It's not on the department. They don't need to bring in any document. Whom is he trying to fool, this consultant from Jhansi, that I have filed a 11-14 application of production of document. It's a waste. The onus is entirely on him. Till he doesn't get the permission from the court to actually seek that 11-14 application, where is that relief? Now he says resumption notice. 2013 policy is pleading. He has not read it. It is not a policy. It is an internal circulation issued by the DG then. I'm surprised. What is he doing? These are guidelines. In that same guideline, it is admitted. He is pleading in one of his para that the guideline says if the bungalow is deflated, it can be resumed. So it's gone. It's written. This man will only get a breather. I pray to God that he gets a stay, and the case goes on. And then he'll only get a breather. But he'll have to amend his plaint. He will have to amend his replications. If he doesn't do this, he has to make sure what issues are being made. This case is a shut and open case. Now 1836, what is he saying? It's very important to see here. He says 1836, Punjab was under the Sikh rule. Agreed. It was never annexed to the British. Absolutely agreeable. But what are the facts? Maharaja Ranjit Singh had signed a treaty with the British in 1811. I have various judgments of Peshawar, Rawalpindi, where the applicability of GGO has been upheld. Devanchand Peshoria's case, which he is mentioning in the very next para, that 1983, he doesn't know that this case has been dismissed in 2021, Civil Appeal number 3208. It was a well fought case, no doubt about it. He had picked up a very good pleading that because I was under the non-regulation territories, the Governor General order had to be promulgated for Amritsar cantonment. So those pleadings made him win. Then he got in a beautiful judgment of law, Rawalpindi. We have to understand in the very next para what is my learned counsel or my consultant is saying. GGO regulation number 5 and 6. He's pleaded that grant had to be registered. What is he? This entire plaint is of indiscriminative pleadings. One side he is saying I'm a freehold, I'm an ownership. So, and the other side he is asking that my grant should have been registered. I don't understand. Guys, I get sick. My whole day goes on this. Because I'm very concerned. Because I know if any one of us lose after 2018-20, we all lose. It's going to be a bad name. It's no point then creating so much of videos, trying to garner 700 people every morning, trying to wake them up. Then finally one day we all will lose. Pray to God, then we go to the excised area of the civil, and then maybe with the local administration we can delay our resumptions. But land will not be ours. You know, in this para, what he is pleading is very dangerous. He says, bungalow number 4 is not a grant. What is it then? He doesn't know that when the Britishers actually moved into the Diwani as the custodians of the then, in 1763-65, lands owned or tilled or occupied by whether Badshai grants or non-Badshai grants, the Britishers recognized those grants. And then settlements took place. Now he says he is not a grant. So 1836 there were no ownerships. Ownership had to come through a board of revenue or through a settlement, not otherwise. So will this bungalow owner or this Mr. Vipin or this consultant from Jhansi, will he manage getting the settlement report of this bungalow in particular and survey number or khasra number? I don't know. I don't even see it far and far side that he has any record of Jalandhar. So we have to be very clear. What was the resumption notice issued to this bungalow, that is in 1918, which I had mentioned in my video? That was Lala Narsingh Das, who had actually purchased this property from Mrs. E.P. Salt or Mrs. Salt after 1907. And Mrs. Salt is selling Lala Fateh Chand the same property on 18th May 1918. So were these two bungalows sold? No. 1918, and that is how they are saying was bifurcated into two. But did Lala Narsingh and Lala Fateh Chand jointly sell it to Ramnath? Is anything in production coming there? Which bungalow was resumed in 1913? Was it the whole bungalow number 4 with no survey number with an area of 3.82 acres? So there is no record to this. And I don't know whether this consultant or Mr. Vipin has shared some additional record. So possession of 100 years is waste. Adverse will not get. Withdraw the resumption notice. Why would they withdraw the resumption notice? You fight it out. They will initiate a PP Act on you. 80 CPC fine, cause of action fine. Now comes the most vital is the prayer. So what is the prayer? Degree for declaration to quit the suit property. That this resumption notice is to be abolished. 1. Second, permanent injunction that my possession, my peaceful possession should not be disturbed. Agreed. Any other relief. You know, you'll be surprised. Okay, fine. Mostly in courts, the judges only read the first paras, head notes, and the prayer. They are not interested in the plaint. Plaint is only heard at the time of argument or making of issues or at when evidence is being led. So here he could have asked a correction of GLR. Here he could have asked compensation simultaneously for this HOR, which he is claiming in one of his paras, that the compensation, plot or whatever. He could have asked even on an issue that whether the GGO was applicable in Jalandhar or in the Sikh terrain. He didn't know all this. How will he ask then? So friends, please, hire consultants, but I say one thing throughout my life. भैया विश्वास करना है तो आंखें खोल के करना है. Abhi recently somebody shared it with me that this consultant in Jalandhar has been seeking 50,000 rupees grant for resumption and consultations, 10,000 rupees per visit. Calculate this expenditure, photocopying. Does he have evidence? He has some books which I shared with Jhansi Cantonment. So he'll manage giving you those books, photocopies in that format. Rest. As an RTI activist, how many GLRs is he holding? How many sale deeds is he holding? Not only of his cantonment, anywhere. It's very important. These pleadings will only bring down your entire case. And if your base is not strong, that is lower court plaint is not strong, finished. So please, Mr. Vipin, my humble request, first of all, make yourself a party in this case. Otherwise, like Chitra Kumari, you will not be even endorsed after resumption for compensation. Third, amend your plaint or add in after the stay provisionally given to you, I hope and I pray. Amend your plaint immediately, because if you do not amend your plaint, your pleadings and issues and evidences will be very tough on. I hope these two brothers in Jalandhar who are pretty activized now, please guys study. Give your time to the cantonment issue. Don't harp on half-cocked information. Don't become fools. I'm being very straight. I'm grateful to the people who supported me in getting this plaint and Mr. Vipin. I had already written him that I'll be making a video and a brief on his plaint, which I'll definitely share with him. I don't need money. I need him to win. See, if I am professionally attached, then I'm not doing anything free. A bungalow owner can talk to me anytime on his issues. Proviso, he's honest to it. I can also sense it. You can't use me for a dustbin. You can use me for your betterment. So please, we guys are old grants, never converted into new grants, because we were revenue free grants. Thank you. Good day.